when you look at the industry as it is today, they are able to employ lobbyists in Baton Rouge. I checked with the Secretary of State where lobbyists have to be registered. Lobbyists who represent at least one healthcare provider. There are 82 of them. Guess how many represent victims of medical malpractice?
None.
Zero. Until this organization has come along. No one. Is it any wonder then why our laws are the way they are?
No, I think that speaks volumes right there.
Welcome to Bayou Justice, Breaking Victims, Protecting Power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State. Welcome to another episode of Bayou Justice, Breaking Victims and Protecting Power, a production of the Louisiana Patient Rights Advocacy Forum. I'm your host, Chip Wagar, and I have with me today a guest, Mike Gertler, who has been practicing law for, well, should we say how long?
56 years.
56 years.
I admit.
He's back with Abraham Lincoln and people like that.
That was my mentor, and I remember him well. But I appreciate you inviting me today. Thank you, Chip.
It's my pleasure, and I'm so glad you came. Mike, you're a Tulane graduate, I believe, as am I.
Yes.
And you've been. I could go through all the awards you've got here. I mean, you won't do it, so but you have been selected top trial lawyer, super lawyer, top lawyer in New Orleans, who's who in America. I could go on and on and on, but let's just say that Mike's been around and seen a lot.
Seen a lot and still looking, still working,
still looking for justice,
still after justice. Yes.
I wanted to. I thought I would start because we've had some younger lawyers here who are very concerned about the Louisiana Medical Malpractice Act because the amount of money that the cap provides is dates back to 1975, and as the years go on and the shrinking buying power of the dollar is what it is, I think it's. I found out it's like we've had like 457% inflation since 1975. Okay, so $500,000 today is not what it was back in 1975. No, and they're worried because, it may eventually become impossible to take medical malpractice cases, because
certainly
of the expense and the risk. Does that your experience as well?
Absolutely, in both respects. First of all, I feel terrible about the fact that the value of the dollar is not taken into account. When they first assigned $500,000 as a maximum amount of money that a person who's injured, whether it be a life-ending injury or a life-saving injury that lasts for a lifetime, is all that individual can recover. So in 1975, Chip, and I remember that year well, believe me, in 1975, a $500,000 award may have been unusual, but today, just turn on the television, see the amounts of money that are awarded to people who do not necessarily have long-term injuries or suffer life-ending injuries. And you get to understand how unfair, uniquely unfair, the Medical Malpractice Act in Louisiana is to people. And, I have definite empathy there completely, and
because
appreciate that.
A cap like this doesn't affect people with minor injuries.
Right.
It's the catastrophically injured. In your experience, can medical malpractice injuries be as catastrophic and devastating as any other kind of personal injury?
Most certainly, because, you're dealing with a human being directly. Your various medical care personnel, from doctors to nurses to nursing homes to, whatever facility, hospitals, all deal directly with your health. And if they operate below what you expect as a standard of care to apply to them and cause you injury, in many instances, is devastating. It can affect the heart, it can affect the lungs, it can affect, in my case, I handled a number of injuries involving shoulders, artificial devices that are implanted, supposedly to help you, and turned out to be devastating. But again, that cap, that $500,000, didn't even touch the consequences to these people.
Now, I want to talk to you about the whole rationale for this draconian law, which our organization feels, when you compare it to the 26 other states that have medical malpractice caps, is the most restrict. No other state restricts the damages that the wrongdoer has to pay to $100,000. No, there is no other state that has anything like that, that's so low. And I wanted to talk to you a moment about, because you've been around long enough, we're old timers here, to remember the hoopla around the reasons this was passed. And this was passed to supposedly rescue the medical profession and hospitals and nursing homes and so forth from the effects of premium increases in the 1970s that had to be controlled, or God forbid the doctors were going to leave the state. The whole system was going to collapse, and so on and so forth. You remember all that.
Oh, I remember it well, and I remember that there was no direct evidence presented to support that contention. And that's what bothered me the most. It was just a claim, as if you were making a political claim, and it was unsupported and unfair, and the rest of us, lawyers, engineers, other professionals, we have to deal with the consequences of the marketplace. In this instance, doctors have no concern whatsoever about the consequences of their actions to affect their insurance. It's $100,000 is all they have to have according to state law, and with a relatively small premium. And it's just
most people have homeowners insurance that's more than that.
Exactly.
And you're bringing up an interesting point. For lawyers, we don't have any caps.
No caps.
In fact, it's unethical and will subject us to discipline from the bar if we attempt in any way to limit our liability to our clients.
Absolutely.
It's an offense itself to put in a contract any attempt to limit your liability.
Well, it's a general understanding that if you do many, many bad things that affect your premium, that you'll stop doing those bad things because there are consequences for your actions. In the medical field, there are absolutely no consequences whatsoever. And that's contrary to good reason and good understanding and good logic. There should not be that kind of protection.
Some people have said, if you want to reduce medical malpractice damage awards, reduce medical malpractice.
That's a pretty straightforward way of looking at it.
Patient safety.
Yeah, that's critical.
And I think that brings up an interesting point about checks and balances, really, and consequences. If your insurance premium's going up because you've had a lot of accidents, there's a reason that it's going up.
Oh, absolutely.
And if you don't have to face the consequences of your reckless driving or drunk driving or whatever, you're probably going to continue doing it.
Well, you certainly won't have any incentive not to do it or not to be more careful than you had been in the past.
And when you think about it, with medical malpractice, if nursing homes and mega chain hospitals that are billion-dollar enterprises today, I mean, like LSU medical healthcare system that owns, I think, 4 or 5 hospitals now, and they're in partnership with like 20 more. Ochsner owns like 30 or 40 hospitals and has 37,000 employees. Their CEO that just retired a few years ago was making a salary of $9 million a year, and all of their top executives made salaries of between $1 and $3 million a year.
Better than being a saint.
Yeah, better than being a lawyer.
Yeah, well, that's for sure.
These are huge conglomerates now, quite different from when we were young. Right? When we had the little individual practitioners in their little individual offices and maybe came to your house with a little black bag.
Yes.
Those days are gone.
Totally gone. It's not personal anymore. It's how these corporations run on the basis of how many patients can you see in what short period of time, and keep going and keep providing medical services that maybe that patient doesn't necessarily mean, but it's money to the corporation. And it's a real big problem in my view today, as you point out, because of the change in ownership and how the big corporations operate. Versus the good old days when I remember when our pediatrician or our doctor came to our house, and, it was a real close relationship.
And, New Orleans had, back in the day, philanthropists. A lot of people don't realize this, but a lot of medical care was provided by the Catholic Church, the Sisters of Charity, and so forth. They weren't in it for the money.
Right.
A lot of people don't realize Touro Infirmary was founded by Judah Touro back in the 19th century, actually, as a hospital that the Jewish community could, but it wasn't restricted to just the Jewish community, but to be sure that the Jewish community was served. Again, not in it for the money. It's in it for giving care and so forth. There was a lot of care in New Orleans, and I've just mentioned a couple that was provided not for money, but to serve the community above all. Right. Those days there's no charity hospital now.
No, gone.
And I don't even know Touro Infirmary is it still a charitable?
I would say, that I'm not qualified to absolutely say, but the sense I get is it's just like the other corporations that have now applied the corporate management theory to everything, not the charitable giving theory that once was.
So these institutions, these hospitals, these nursing homes and so forth, and the nursing home industry is the same. Now it's like national chain corporations that own dozens of nursing homes, including in Louisiana, and some local owners, famously the Bob Dean, nursing homes, infamous example. They're all maximum liability for negligence that injures and kills patients is $100,000.
Yeah. If I remember, and I wasn't involved in the litigation, but I know when the litigation was going on regarding the nursing homes and the care that wasn't provided during the hurricane season and so forth and so forth.
Old people housed in sweltering warehouses and so forth where they died and so forth.
And the only really ultimate result, because of what you've pointed out, is bankruptcy. And what's happened is if, they had inadequate insurance, inadequate coverage, and at the end of the day, if they decided the best route was simply go bankrupt on everybody, that's what happens. They just take that recourse, which is not to the patient's benefit at all. It's simply a corporate decision.
And their insurance company only has to pay $100,000.
That's it. That's $100,000. The first $100,000 comes directly from the individual or from the healthcare provider. After that, to get to the $500,000 limit we've been talking about, they simply contribute to a fund managed by the state.
A little surcharge on top of there.
Call it a surcharge. And then that's the protection they get from 100 to 500, not from their insurance, not from their pocket, but from this contribution, this surcharge that everybody puts in and has the protection.
I've, on another episode of this podcast, I related some statistics to our viewers about the impact that this draconian law from 1975 that's gone unchanged for now half a century has had on insurance premiums for doctors and hospitals. And I'll mention it again. In 1975, the insurance commissioner at that time, Commissioner Hodges, testified before a legislative committee that was considering this terrible law, that Louisiana ranked 25th, mid-20s in the cost of insurance premiums for our doctors and hospitals and so forth. 30 years later, in spite of this law, in spite of all the misery it's caused, in spite of all the catastrophically injured people who've been denied full and fair compensation, Louisiana had climbed to 17th most expensive. And today, 50 years on, we're in the 8th position, 8th most expensive state in insurance premiums. That's by the Cunningham Group, a national brokerage firm for medical malpractice insurance. So all this that you hear from the people who want to, justify what's going on is that if we didn't have this, all the doctors would leave the state and the system would collapse and so forth. The evidence doesn't really bear that out, does it?
Not at all. From what you told me is, that the Medical Malpractice Act itself did nothing to control insurance costs. And specifically when it came to the doctors, the only thing that benefited them was that they only had to obtain $100,000 in insurance coverage, which meant even if the cost went up, they only needed $100,000, which wasn't costly as a general rule to them. So what is the final conclusion? All this act did was protect these medical providers and did nothing to reduce the level of medical malpractice, did nothing to reduce the premiums, but the insurance companies, and had no beneficial consequence, in my opinion, whatsoever. I can't see it.
And back in the 70s and before that, a wide number of medical doctors practice in their own practice, individually and so forth. That's not the case today. No. I think I've heard the Ochsner medical system employs at or above 50% of the doctors in the state. So the doctors are not paying for the medical insurance premiums. These huge multi-billion-dollar corporations that are paying their executives, interestingly, as nonprofits, are paying their executives million-dollar salaries and so forth.
Something's got to be wrong with that.
Something's got to be wrong there. Another thing I think that's interesting is when you look at the industry as it is today, they are able to employ lobbyists in Baton Rouge. I checked with the Secretary of State, where lobbyists have to be registered. Lobbyists who represent at least one healthcare provider, there are 82 of them. Wow. 82 of them. Guess how many represent victims of medical malpractice?
None.
Zero until this organization has come along. Yeah, no one. Is it any wonder then why our laws are the way they are?
No, I think that speaks volumes right there.
I want to bring up an article today I have from Utah. I think we were talking about it before we went on. In Utah, there was a bill. Utah doesn't have medical malpractice caps. I don't know if they were declared unconstitutional. Many states have declared these laws unconstitutional, but not Louisiana.
Yeah, of course not.
And but I don't know. Maybe they never had one, but they don't have any caps and so forth. And so this is a March 4th, 2025 article, and today's the 7th of March, so just a few days ago. This legislator, Katie Hall from South Ogden, Utah, decided that they needed one and attempted and did introduce a bill to limit medical malpractice payouts to victims at $1 million, which is twice as much as what Louisiana has from 1975.
Yeah.
And it caused such an uproar and such an outrage. It was called devastating. It would be a devastating cap or outrageous cap and so forth, that eventually the bill was withdrawn and killed in the Utah legislature.
Good for them. That was a general public that understood the consequences and stood up for the patient as opposed to the corporate interests.
And you know, another thing that I think you've seen over the years, and so have I, if you look at the U.S. News World Report, there are several credible agencies that rank the states as far as quality of health care goes, quality of nursing homes and so forth. From what I've seen in the last few years, and I'm sure it's not new, Louisiana ranks in the high 40s all the time, 47th, 48th, 49th, and in one I saw even 50th, last place as far as quality of care goes. So what we were talking about this earlier, consequences and so forth. What is the check and balance for patient safety like here in Louisiana?
Mm-hmm. Well, it certainly doesn't come through, as we talked about, doesn't come through responsibility for insurance or the consequences of not having adequate insurance. I don't know. I really don't know what is the checkpoint on that, what keeps that.
We don't seem to have a very robust self-policing system here with the State Board of Medical Examiners, which are the ones that control. Unless the only ones I've ever seen are drug. If the doctor's got a drug addiction or alcoholism, and is performing surgeries and things like that, you just because you've been found guilty over and over again of malpractice, you're not going to lose your license in Louisiana.
I would doubt it seriously.
I haven't seen it.
But I tell you, it's not the thing that bothers me the most is when you go back to the fact that this was a amount that was imposed 50 years ago, 1975, with nothing to affect the value of money and how that changes. And when you just think about the cost of groceries in 1975,
cars, houses,
everyday items, and how they've dramatically changed and increased, in cost, and then you didn't care enough about human beings that are damaged by the consequences of negligence of certain physicians, hospitals, nursing homes, or whatever. There's something just so dramatically wrong with that. And yet I do not see, because you point out where the legislature has not even addressed or thought about increasing that amount. It's just bothersome.
The thing that gives me a pinhole of hope, a ray, a shaft of sunlight here with this thing that happened in Utah a few days ago and so forth, is that people raising their voices, people going to the Capitol, people contacting their legislators and so forth, does have an effect. We will never outmoney the other side.
Right.
It's got to be from grassroots, and that's what this organization is trying to do. Spread public awareness of how draconian and how backward our law is in comparison to any other state in this country. Why should Louisianians have any less rights than people in Alabama? Alabama doesn't have caps. Florida doesn't have caps. Georgia doesn't have caps. Arkansas doesn't have caps. Oklahoma doesn't have caps. Why should we have less rights here than anybody else?
Absolutely. And what you're talking about when you say caps, yes, we're talking about caps on compensation for injuries. But the basis for the caps is that the medical providers need to provide a standard of care that's accepted generally, when you talk about specialists, throughout the country. But it's irrelevant when you put the damages so low that there's no incentive to comply. And that also, I know
that might have something to do with why we're ranked 48th and 50th in quality of care.
Good, very well, you know. And I know we don't have time to go into all the technicalities, but you know what we as Louisianians have to go through under the Medical Malpractice Act to even get to that cap is just outrageous. It's so burdensome. It delays are so long, and people get so frustrated, and that's your basis for even getting to hopefully an appropriate cap.
It's like Sisyphus there. When you get to the mountaintop, the rock rolls back down on top of you, doesn't it?
Exactly.
You know?
Yeah.
I think people also have the opinion that without caps, there would be a flood of litigation against doctors and hospitals, and that we would have all these jackpot verdicts. Mm-hmm. Something I think people don't realize unless you do this, as you and I have, medical malpractice cases are not easy to win.
No, very difficult.
They're very difficult. And even if you took the caps off, even if you took the medical review panel system that 90% of the time finds nothing wrong, you know, with their colleagues, even if you took that off, they're not, juries do not give awards for medical malpractice very easily, do they?
No, because jurors have doctors, and their first sympathy, I think, is to the fact that their doctor may be upset if they do something that would be contrary to the welfare of the doctor on trial. So you have to get over a lot of layers of difficulty in medical malpractice. And as you point out, just to find another doctor in the most grievous situation to testify against a doctor.
Or we go out of state. We don't even bother to look here.
And when you go out of state, you're talking about thousands and thousands
$10,000 a day to come here.
Just to come here and tell the obvious. Yes, it was a breach of standard of care. Yes, it was the consequence of that breach that caused this injury. And most lawyers don't have the kinds of, funds to pay for that.
Or cast iron stomach to take the risk, you know?
Yeah.
It is a risk.
That makes it doubly hard in medical malpractice. And I think your organization is so needed and hopefully will be so helpful in bringing this to the attention of the general public.
Well, we are now publishing a monthly newsletter to 105 members of the House of Representatives and 39 senators in the Senate, because what we have found is that many of them, maybe even the majority of them in the legislature, have no idea that this even exists.
Right.
They don't even know that there was caps. They don't even know that only 16 states have a medical review panel system. Even the states that have medical malpractice laws, use a much different system, an affidavit system, for example, like in Texas or Mississippi.
Right.
And they don't know any of this. So when someone like the Louisiana Association for Justice goes to talk with these people, they have nothing to work with. They're starting from scratch, so to speak.
And they haven't been affected directly, maybe, so they don't understand.
No.
Don't have the empathy, maybe, to understand.
So we're bringing the word to these people every month now, and then we're giving them the same facts that we've talked about on this podcast many times, to make them realize we're an outlier. Louisiana is an outlier in this area, and the victims are the catastrophically injured people, not people with minor injuries that still fall within the cap. These are people with brain damage, paralysis, death, amputations of limbs and things of that nature. These are the people, and there's actually, statistically speaking, there's not that many of them. There's maybe, thank God, but I mean, maybe a few hundred. That's a few hundred too many. But I mean, you're talking about placing a burden, a massive burden of devastating life injury on people who are least able to bear it and afford it, to save a multi-billion-dollar mega hospital chain or a multi-billion-dollar nursing home chain and so forth, and a profession which is the richest, most affluent profession in the country.
Yeah. In my experience, most lawyers that I know wouldn't even take a minor case involving a minor injury, involving medical malpractice.
It's too expensive.
It's too expensive. It's too burdensome. The delays are too long. It's just they don't take them. So you're talking about, at the minimum, mid-range injuries to the most extraordinary injuries that are suffering the most.
We have to tell people, you probably have this experience too at your law firm, look, I'm going to, since you can't pay us by the hour, most of our clients are not in that financial position. We're going to do a contingency fee. Once we take that out, once we take $50,000, $75,000, $100,000 in expenses that we're going to have to, there's nothing left for you. No. It's not worth it. It's not worth it. And it's terrible to have to tell them that. I wish I could take it, but I can't.
No, you're absolutely
if I took all those cases, I'd be out of business. I couldn't help anybody.
Well, we put in a lot of time and effort. That's just, from our viewpoint, won't be paid forever because of how we feel about the patients or the people who are injured. It's just that we have that feeling that we need to do the best job we can, but it's never paid in full in terms of monetary reward.
Every time I give a settlement check, or a payment for a judgment to one of my clients, I tell them, it's not enough.
No.
It's not enough.
No.
I'm sorry.
No.
I hate to say that to them because there's, a lot of them are poor or working class, and, they're getting a check for $500,000 and so forth. But you're going to have that for the rest of your life. That's it. That's all that's all you're going to get. And they're happy to get it. Of course they are. Yeah. And it is some help, but it is nothing to what they're going to have to bear, know?
No, absolutely true. And, again, get back to what I said at the very beginning, compare that to, you see a healthy, wonderful person on television saying, I got blah, 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 I got all this money, and look, I'm doing great. And look at you, you're affected the rest of your life, and you get peanuts.
I have a case right now I'm thinking about. This man's a quadruple amputee. He has no arms and no legs.
Yeah, wow.
And the doctor who's responsible is in prison for tax evasion. liability was stipulated. Malpractice, no contest.
Yeah.
Did not contest it.
Horrible.
She and her insurance company paid $100,000 to this guy.
Walked away.
Yeah.
Well, that's a perfect example of what we're trying to say today.
Yeah. We need to do something about
Yes.
this. And so what we're trying to do is educate the legislature, educate the general public, all people that'll be watching this video on YouTube and TikTok or,
Wherever they do these days.
I think Spotify and raise awareness and so forth and develop a grassroots effort that, like what happened in Utah, when this comes up, to change this terrible law, that we can do it, that legislators feel safe enough that they can defy the lobbyists roaming the halls, the 80-some lobbyists roaming the halls of the Louisiana legislature, and do something for the people of Louisiana, because their constituents have less rights than anybody else in the country. And you know what? A lot of the legislators will be touched by malpractice in their life. A lot of them don't realize it's the third leading cause of death in this country.
Wow.
A lot of them don't know that 1 out of 9 times you go into a hospital, you will be injured or killed in that hospital by the staff. They don't realize how prevalent it is and how devastating it can be, and it can touch you. In fact, if you live long enough, it probably will touch you at some point. So you or someone you love will be affected by medical malpractice.
Well, thank goodness you're doing that good work.
Well, thank you so much, Mike, for being here today and sharing your own experiences with this. We really appreciate it, and I hope we can do this again someday. So for all of us at the Patient Rights Advocacy Forum, thank you for watching today and listening to this video. And please visit our website. It's www.patientrightsla, like the state of Louisiana, LA, patientrightsla.com. Come visit our website, and you can learn more details about medical malpractice in Louisiana. And you can write to us, you can donate to us, to our cause, and I hope you will. Thanks for watching.
Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.